Welcome back, and I hope you enjoyed your coffee. Before we proceed to panel 6, the last panel of the conference, I will ask my colleagues to post the final motion of the conference to the screen. The Slido motion is: the ICC is on the right track to reach its full potential. Agree or disagree? You know how Slido works, I will skip that. And now I will introduce panel 6. Our chair, Professor Klaus Kreß, is another longtime advocate of and expert in international criminal law. The director of the Institute of International Peace and Security Law at the University Zukoln, he served as a member of the German delegation to the ICC processes since 1998 and currently serves as a special advisor to the prosecutor of the ICC on the crime of aggression. He will preside over another very accomplished panel, including Professors Paola Gaeta, who is participating remotely, Carsten, Stahn, and Leila Sadat of the Graduate Institute of International and Development Studies, the University of Leiden, and Washington University School of Law, respectively. It is hard to imagine a panel better equipped to help cast our minds forward 20 years to the ICC of 2042. What will the ICC of the future look like? How will we look back at the coming 20 years in terms of accomplishments and tasks yet to be taken up? It is a daunting but essential question, and I leave it to these brilliant minds to tackle it. I turn the floor over to Professor Kreß.
Thank you very much, Jennifer. Excellencies, distinguished colleagues, ladies and gentlemen, dear friends. I welcome you all to our closing panel, and I would like to begin with a warm welcome to all those sitting a little bit more in the back of the room, with a warm invitation. Some seats are empty. Please feel free to move a little closer. It would make for an intimate atmosphere as we close our deliberations. Just that you know, take the opportunity to come closer to the microphones, to the panel. Let me start with a compliment to the audience. It's the end of 3 days of intense deliberation. It's Saturday afternoon. The sun has come out, and you have stayed in. And looking back to the debates we have just had, it is clear to me you have stayed all to the end, not just by courtesy, which would have been a thing to appreciate by itself, but, and that's, I think, characteristic for this audience, by dedication to our subject and by burning interest. And we shall try to do our modest share that also the end will contribute to what has been such an inspiring meeting for more than 2 days now. It is an immense privilege to be here with 3 very distinguished colleagues and long-lasting friends. Perhaps I extend the first word of hello to Paola, whom we are so happy to see, digitally collected, and then, of course, Professor Leila Sadat and Carsten Stahn. I think it really would be a waste of time to introduce their scholarship to you. You know them all. They are 3 internationally recognized and leading authorities on the subject. There's not more to say on this, but I would perhaps wish to add one thing which makes it so interesting reading what they do. They are scholars in the finest sense of the term, so always ready to criticize where this is needed. But when they do this constructively, this has also to do with the fact that they have always been close and closely looking and following and even been engaged with especially the institution which is at the center of our deliberations. Carsten has even been part of the court for a longer moment of time. Leila is one of the longest standing special advisors to the prosecutors, I should say. And when I look to Paola, I remember her engagement, for example, as an amica curiae, I should say, in correct Latin, in the proceedings before the appeals chamber, for example, in the al-Bashir case. How do we suggest to proceed? Not with any lengthy and distracting words of my own, but just by giving the floor to Leila. Her intervention will be followed by that of Carsten Stahn. It will then be Paola to take the floor digitally. I shall allow myself to make a few personal observations thereafter in the form of a transition to the question and answer section. We will not delay that question and answer section by a conversation amongst us because we are eager to get you involved as much as possible. It will be the final opportunity for you during these deliberations to raise your voices. And in a sense, the topic of this last panel is fairly wide. Take it as a freestyle exercise. Don't feel too bound by any thematic constraints. If you feel there was a point you would have liked before to say, to comment on, to convey to those following us digitally, just move to the microphone and make use of this opportunity before we shall then hear Klaus Rackwitz for his closing remarks. Without further ado, Leila, the floor is yours.
Thank you so much, Klaus, for that wonderful introduction. And it's really an extraordinary privilege to be here once again in this really extraordinary, historic venue. I think of Madeleine Albright when she was at the United Nations creating the ICTY, and she said there's an echo of Nuremberg in this chamber, and here we are in courtroom 600 with a true echo of Nuremberg talking about the future of the International Criminal Court. Thank you so much to the Nuremberg Academy, to all the panelists who have given so much food for thought over the past 2 days, to my fellow panelists for the interventions I'm about to hear, and I have to add my thanks as well to the audience who has persisted and stayed even through 3 days of conversations on a sunny day, on a Saturday in Nuremberg. A few years ago, the late Hans-Peter Cowell delivered a lecture entitled The ICC of the Future. I was there on that occasion, and with his characteristic sense of humor and also his real insight, he gave a lot of food for thought. It was almost 10 years ago now. He examined both the external and the internal environment of the court and how it might progress. He predicted that the court's work culture and the one court principle would be well enshrined, that the United States and China would become parties, at least by 2040, China joining first. He would chuckle when he would predict, or perhaps hope, that meetings would begin on time, the budget would grow, and the working methods of the judiciary, registry, and chambers would improve. And I think actually he would have been pleased both with some of the recommendations of the independent expert report and the responses of the court's organs to them, and I know he would have been thrilled by this excellent conference. As we celebrate this 20th anniversary of the statute's entry into force and contemplate the 25th, the 30th, and even the 40th anniversaries, we can consider, perhaps usefully, developments over the past 20 years and how they may have surprised us, either for good or ill, and reflect upon what we anticipated or successfully predicted at Rome and what we did not. This might allow us to perceive more successfully the outlines of future developments. And so in my short time today, I would like to consider both some of the external factors influencing the success and direction of the ICC and some of the internal issues. On the macro level, if the 1990s were dubbed by the General Assembly the decade of international law, we might consider the 2020s as the decade of global dysfunction, as the Secretary General of the United Nations, Antonio Guterres, recently observed. A time of pandemic, war, climate change, human migration, and rising global authoritarianism, which are stressing the global ecosystem. The Rome Statute was negotiated following the collapse of the Soviet Union in what Professor Richard Falk described as a shadowland in which future structures could be seen or glimpsed, but not yet created. There was a window of opportunity at Rome to create the last great international institution of the 20th century, and able individuals seized upon that opportunity and got the work done. So what did we expect in that time of optimism in the 1990s? Well, one consensus was that it would take decades for the ICC statute to enter into force with the necessary 60 ratifications. To have it happen in 4 years was astonishing. We also worried in 1998 that no state would ever refer a case to the court, hence the need for an independent prosecutor. After all, at that time, no state had ever used the interstate complaint mechanisms in the human rights treaties, so why would they refer criminal cases? Yet Luis Moreno Ocampo, sitting right in front of me, immediately invited states to refer situations on their own territories, and they did. The situation in the DRC and Uganda were first, and more followed. While the self-referrals raised some questions about objectivity, they ensured that OTP would have access to crime scenes and evidence, and at least some modicum of state cooperation. This allowed the office to bring charges in Lubanga, in Katanga, Ambarushimana, Chui, Nidaganda, Angwin, and other cases, and even if not all the cases resulted in successful convictions, they got the court up and running in terms of its judicial activity. And as an aside, petit parenthèse, I do think a significant measure of the court's success probably is its caseload. That's not the only metric, but it's an important one. The threat of indictment and conviction has to be credible to be effective, and state funding demands action, as Luis himself understood, I think, all too well at the beginning of his tenure. Not only did states refer their own situations, but they then began to refer situations involving other states. On September 26, 2018, 6 states, Argentina, Canada, Chile, Colombia, Paraguay, and Peru, jointly referred the situation in Venezuela to the ICC. As one commentator noted at the time, because the situation in Venezuela was already the subject of our preliminary examination, the state party referral did not really change the legal situation, but it had the effect of serving as a formal display of political support, much needed for the office to do its work. Likewise, when Prosecutor Khan himself wished to move the situation in Ukraine from the preliminary examination stage to investigation, he invited states to refer the situation to him to avoid having to go to a pretrial chamber for approval. 39 states did so in short order, followed by 4 others. This political support has also translated into financial support for the court, which is very helpful to its overall mission. Conversely, while the proprio moto power of the office remains important, as does the Security Council referral process, these have posed challenges to the office. Kenya was the first use of the proprio motu power, and the lack of state cooperation was troublesome from the start, ultimately derailing cases, even if the investigation and prosecution may have produced some salutary effects, as Beth Simmons suggested yesterday. Philippines and Burundi have withdrawn, faced with investigations launched by the prosecutor, and although 3 arrest warrants were authorized in the Georgia situation, also proprio motu, just this summer, with requests for cooperation following, that may not be very easy to implement. The Security Council referrals have also been hamstrung by a lack of financial support from the Council and backing from the Council, and states have even used the veto even in the face of atrocity crime commission. So clearly we see that while states are sometimes supporting the court, they are also often looking to the court to assist in trouble spots, but not yet fully on board. We worried in the 1990s that states might try to pressure the court and undermine its independence, and we were right to worry about that. But I don't think we could have imagined the Article 98 bilateral immunity campaign or the punishing U.S. pressure on OTP to drop the Afghanistan investigation, pressure so intense that it arguably warped the jurisprudence and resulted in the imposition of punishing sanctions on Prosecutor Bensouda and one of her deputies. Although the U.S. sanctions were eventually lifted when a new president was inaugurated, the awful precedent was set, and it's not impossible that the court might face similar attacks in the future. It's a testament to the state's parties that rallied around the office and the court, as well as the personal courage of the staff inside the building, that the prosecutor and the court weathered the storm. Inside the court, one of the most interesting positive developments, I think, which I tried to get the judges to talk about initially, has been the continued evolution of international criminal law. If the prosecutor is the engine of the court, the jurisprudence, the means by which the court speaks law to power, is its voice. Although fractured opinions occasionally have slowed the court perhaps in finding that voice, there have been some important judgments regarding substantive ICC law. I don't think we predicted how difficult the judicial task would be, nor how important it would be. As the court enters its third decade, however, the decision on child soldiers, on rape and sexual slavery, forced marriage, forced pregnancy, definition of armed conflict, attacks on cultural property, and even procedures such as guilty pleas and defenses have become so important and enormous contributions to the evolution of international criminal law. I think that the judges of the future ICC will find even more opportunities to advance and enhance international criminal law as they continue to adjudicate cases from around the world while maintaining, of course, the rights of the accused. The al-Bashir immunity case, I think, is also a jurisprudential high-water mark. In terms of substantive law, the final act of the diplomatic conference left the door open for the inclusion of the crime of aggression as well as treaty crimes. The aggression amendments happened, but with jurisdictional limitations that damaged the unitary treatment of the 4 ICC core crimes and their adjudication. The Ukraine situation underscores the inappropriateness of those limits, I believe, and I hope that someday they will be undone. As for treaty crimes or other new offenses, such as ecocide proposed here, I don't see that much enthusiasm, either among states, parties, or others for their inclusion, and given the problematic incorporation of aggression, wonder whether adding new crimes to the ICC will work very effectively. However, ICL continues to grow. We have seen proposals for a new anti-corruption court, and we've also seen the development of a new treaty on crimes against humanity sitting in the General Assembly just this week with a resolution introduced by 60 states. Finally, in terms of procedure, I don't think we predicted how poorly the hoped felicitous marriage of the common law and civil law systems would create, and how the addition of the pretrial chamber would render procedure complex and lengthen rather than shorten the time of judicial proceedings. As a personal plea, I do hope that we will eventually abandon the overly complex overlay on Article 25, resulting, in my view, from over-enthusiastic interpretation of its provisions by legal scholars, and settle into a jurisprudence that can address system criminality and mass atrocities without the addition of sometimes numbingly complex doctrines like the control of the crime theory, plucked out of national legal systems and implanted into the ICC statute. And I say that as a professor of international criminal law that has to teach direct and indirect co-perpetration. Although there is much more that could be said about the ICC of the future, given the pressure of time, I would just like to make a couple comments about universality as it goes to legitimacy, as well as effectiveness and independence. We've seen that the ICC works best when states support it, meaning that universal ratification remains a critical goal. State parties provide funding to the court, they have legal obligations to cooperate. There are 123 states parties now, and a handful of others that either were parties or have submitted declarations. Increasing that number is paramount. Will it be China, as Judge Cowell imagined? I don't think so. Of course, things can change. Could it be the United States? Maybe. The situation in Ukraine has really changed U.S. perceptions, and a good bit of that change is bipartisan, not just Democrats, not counting John Bolton. As a famous American baseball player, Yogi Berra, once noted, it's tough to make predictions, especially about the future. I am painfully aware, as a U.S. citizen, of the vitriol and anger directed at the court by the prior administration in my country. And as some of you know, I was the lead plaintiff in one of the 2 lawsuits brought against the Trump administration, alleging that the sanction regime was actually unconstitutional. But in my view, bluster and anger show as much weakness as they do strength. Interestingly, in a recent survey of federal case law that one of my research assistants just did, we found 91 federal court cases citing the ICC statute as authority for a variety of legal propositions inside the United States legal system. Those committed to international justice and to this court never wavered in their belief, even in my country, that this court was important to peace, justice, and accountability as a cornerstone of an important world under the rule of law. Depending on the trajectory of the ICC over the next few years, I think U.S. opposition could soften and ratification become invisible if we remain persistent inside our country, at least by 2040 or 42. It did take the United States 40 years to ratify the Genocide Convention. So what about other states? And I'm almost done here. What about the problem of double standards? This is my final point. The public and even scholars often discuss ICC situations in terms of winners and losers, states either benefiting from ICC attention when other states are not, like Ukraine, or states being targeted by the ICC when other states are not, like the AU complaints. This, however, in my view, is an improperly framed narrative that even ICL scholars have fallen into. The ICC never targets states. It prosecutes individuals. It is true that as a treaty court, some situations are outside the Rome Treaty. It is also true that the Security Council is a political body that acts or not according to the whims sometimes of the 5 permanent members. And of course, crimes committed by high-ranking state officials may represent state policy. However, in this room, it's important to remember, as Justice Jackson himself observed in this courtroom, that it was not the German people who were in the dock at Nuremberg. It was 22 men. We need to reconceptualize the way we think about selectivity to recognize that the ICC will, by its nature, prosecute individuals over whom it can reasonably and lawfully acquire jurisdiction for the atrocities they are alleged to have committed. Victims of those situations are benefiting from the court's intervention, even if the perpetrators are not. The ICC is not the International Court of Justice before which states are parties, and it would be helpful, I think, to denationalize the manner in which we critique and frame the court's activity. In conclusion, I think that the future of the ICC really is bright, so long as the democracies of the world remain strong. The world could descend into darkness, but as the saying goes, better to light a candle than curse the dark. Thank you so much.
Thank you so much, Leila, for this wonderful opening of our closing panel. I trust you have in between also to a sufficient degree provoked some questions and comments from our judges present, for example, when you refer to Article 25 and some ongoing open subtleties in that respect. And perhaps before passing the floor to Carsten, let me say a personal word of thanks to you, Leila. You have referred back to this very precarious moment when the court was challenged by the administration, a former administration, happily, of your state. You took a very courageous position, and I think this is the model thing to do for a scholar, in particular if it's one's own country, to stand up and speak critically. So thank you for this. And Carsten, we look forward to your intervention.
Thank you so much. It's a dream panel, I think, that we are witnessing in this very courtroom, which translates so much history. And of course, we as academics are given the most difficult task, almost an impossible task, to predict and to give advice how the court could succeed in the future. If we look, I think, at the picture, and Leila has given us, I think, a very good image of the candle, I think, that leads us as a shining light. Nevertheless, if we look at the prospects, if we look at the overall context in which the ICC is operating, we see that the world is getting much more multipolar. The 1990s were really, I think, an exceptional moment. If we look at the democracy index, what we see is a decline in the democratic systems. We see a rise of autocratic systems. If we look at Ukraine, it's to some extent a novel and enlightening moment, a moment of rejuvenating, giving new hope to the court. On the other hand, it also shows that there are continuing divisions, and they're more complex than the divisions of the past. It's not merely as East versus West, it's not really only global South versus global North, but it's much more complex. So I think in this very context, the ICC is needed more than ever, but I would also say we have to be more imaginative as ever in order to make the court ready for the next decades. So I would like to propose a few propositions about how we could imagine the court of the future. So I think the three main challenges that the court needs to face is, first of all, countering perceptions of bias, confronting hegemonies and also post-colonial continuities, and adjusting strategies of international criminal justice to this really new multipolar environment. So what are some of the encouraging trends? What are some of the answers that we see? I think the first idea, which emerges very clearly also from the content of this conference, is that we need to see the ICC as part of a polycentric system of justice. The notion of system of justice has been coined very early, I think, through the interventions of Luis Moreno Campo. It's been present since the start, but the idea was always that the court is in the center of international criminal justice. It's in dialogue with domestic jurisdictions, but what we've seen over the past decades is a rise in hybrid tribunals and new regional formulas. So we need to rethink this idea of complementarity, how it fits beyond this classical dialogue between states and the ICC. How does complementarity function in this polycentric environment? And I think, first of all, it will be essential, I think, to build up new relationships with regional entities, to rethink complementarity beyond these classical criteria of same person, same conduct, and to invest potentially also particularly into complementarity agreements in order to find new solutions. Yesterday, the issue of a division of labor has been raised by you, Claus. I think these conflicts can only be solved through new complementarity agreements of the court with other entities, and this is where I think a lot of new creativity, imagination needs to be invested in. At the same time, at the domestic level, we see a rise in the context of universal jurisdiction cases, but there's still no coordinating mechanism which tells us how these different entities exercising universal jurisdiction, how they should communicate, how they should coordinate their own efforts. So these are, I think, some of the important complementarity dimensions of the future. My second remark relating to the idea of the ICC as a pluralist and a collaborative court is this idea of evidence. We've seen that the crimes become ever more visible, evidence is multiplying, and coordination of evidence, I think, will be one of the crucial issues of the future. And it's a good start to start with these new agreements, the new society, civil society, ICC, Eurojust guidelines on coordination of evidence collecting. But I think we need to really rethink what is the status of evidence actually on the international level. We talk about crimes as being crimes against the international community as a whole. What does this mean for evidence? Is evidence maybe also a kind of universal patrimony of humanity that might need to protect it in future years more than it needs to be in the past, simply because we have so much more entities chasing for the same evidence? So that's a question that I'm posing. My second proposal relates to the idea of how we can confront also the causes of criminality more deeply than merely the symptoms. We've had a discussion on prevention. The visibility of crimes, in my view, will increase, as well as the options for accountability. And this really raises, I think, really novel and profound questions about what cases should the court pursue in the future. And I would argue that it would benefit the court to put greater emphasis also on confronting the causes of violence in accountability strategies rather than only the symptoms. Of course, we all said we cannot overload the court, but I would argue that part of the value of the court lies in its expressive function, the fact that through a very limited number of cases, it can have a global and very important impact. So what are the kind of cases I think I would like the court to address in order to have that impact, in order to confront some of the underlying causes of violence? I think environmental harm cases are critically, and Fatou Bensouda, I think, has mentioned the land grabbing issue, but of course the issue goes much deeper. How does the court actually respond also to non-human harms in its jurisprudence? What signals does it give also to states in this regard? Second important point is, I think, about stretching accountability beyond the classical non-state armed groups and state scenarios. What about cases of business complicity? A lot of the drivers of conflicts, of course, have economic causes. And I think for the ACC to engage in a case on business complicity, and I think, again, Luis Moreno Ocampo has been trying to promote this, but we still haven't seen that kind of breaking case of the ICC where we would see the ICC has really targeted that question. So I think these are just two very important issues. There are other opportunities, cyber warfare, I think, where Ukraine now offers new opportunities for the court to set out some of the undetermined dimensions also in relation to war crimes jurisprudence. Modern slavery, it's just another issue I would mention here. My second suggestion, I think, how the court could go a little bit more deeper into addressing the causes of criminality. Elise von Schlerecht has argued, looking forward, should we think about also the power of the ICC to try corporations? What would it mean for the future? What would it mean for the victims of crimes, for instance? But this is, of course, a de lege ferenda suggestion. I would argue it's very important for the court to go deeper into context. The ICC is obviously not a Truth and Reconciliation Commission, but the ICC will much benefit, I think, from investing in field presence, in regional structures, and in particular also engaging much deeper with the context of these situations. And I think this can be done, and it has been come out in this conference already, for instance, in relation to when you motivate sentencing, and particular also in the context of the reparation practice. So this idea of reparative complementarity will be, I think, very crucial for the court to succeed in its mandate. We've been talking about states providing reparations, but there's actually a new tendency that non-state actors might also make reparations. How would the court encompass that not only an individual then basically provides reparations, but how could we encompass that collective structure also in the reparation process? So I think that's, again, one of the questions for the next decades. My third broader point relates to the question of universality, and Leila has already spoken to it, and many interveners have done that. I would just like to raise one point. How can we think beyond the Security Council? What are the pathways to decrease dependence of the court on the Security Council? Strengthening the independence of the court, I think, will be crucial. And I think one of the interesting developments that we've seen the role of the General Assembly rising with the establishment of the investigative mechanism for Syria. We've had the Assembly establishing the ECCC. We have a discussion what role the Assembly should play in a potential future Ukraine tribunal. So there is this question, what role would we see for the General Assembly in the future? Should the Assembly, for instance, be able, under the Uniting for Peace powers, use them as Uniting for Justice powers, for instance, to make a referral? Of course, for this, you all know the statute would need to be amended because it only allows the Council to make that referral. But again, I think that's one of the options, I think, to at least reflect upon what creative role do we see for the Assembly in addition to the Council. Secondly, if we think about strengthening the system from within, we might also think about how does the court in itself conceive itself as an entity. And here we have different theories about how this court is founded. We have the delegation theory that the court is basically the sum of the power of the state's parties, but we also have the much older jus puniendi theory that the court is actually something else, is something more than the sum of its parties. And in the jurisprudence, and Claus has drawn also in his scholarship, I think, attention to that, we don't have a uniform judgment in the jurisprudence of where the court stands on this foundational issue. We have certain decisions which point towards the delegation theory as a foundation of the court, but then we've seen other decisions, for instance, also in the immunity context, pointing, or in the Palestine PTC decision, pointing a little bit more towards a jus puniendi approach. So I think rethinking this very foundation of the court, how does the court conceive itself? Does it see itself really as a prolonged arm of the power of states, or does it see itself as an expression of something more than merely interstate relations? I think that is a crucial question for the future. My last point on thinking about universality relates also to the question about how can we strengthen universality, not only in terms of global reach, ratifications, but universality in content. And I think this is a very important point. I think if if me as an academic, I study the jurisprudence of the court, I would say it's still very much Eurocentric based, also due to the predominant literature in the field. I would wish sometimes we could invest a little bit more in terms of inclusivity of sources and legal systems, because this might also serve, I think, as an incentive for domestic courts to listen much more closely to the jurisprudence of the ICC. Secondly, I think bringing out the shared foundations of the statute in a more differentiated way than some of the existing decisions like Rahman, which just said the ICC statute simply constitutes customary international law. I think that is a shortcut. I think there's much more differentiation in relation to the different provisions of the ICC statute, and I think recognizing this is important. Last point I want to mention is, I think, the quality of reasoning. If we think about how the court explains its decisions, Klaus Kreß has just made, I think, an impressive example in the Gambia versus Myanmar case, pleading for the idea that jurisprudence lives through its transparency, lives through the explanation of legal reasoning. And investing and setting out, I think, the jurisprudence and the legal reasoning behind the decisions, also with references to prior decisions, etc., I think is a good example. Conceiving the ICC as a part of what I would call the invisible community of courts. At the same time, I think it's important to also be aware of some of the post-colonial continuities. For instance, I think in the Palestine situation, the reference to self-determination was an obiter dictum, but it was a very important obiter dictum in terms of the ICC engaging with some of the broader historical ramifications of the situation in which it engages. Let me close with my last point. Looking towards the future, I would wish for the ICC to be a resilient court. So a court which navigates politics, but which does so in a resilient way. So the court is, and we see that also even in the context of Ukraine, is often used as an instrument of lawfare also by states for their own policies. So I think what is important for the court is, first of all, to invest in the idea as part of the communicative structure, to strengthen the ability of the court to confront mis- and disinformation. I think Leila has played a very important role in relation to the US campaign, but I think if we look towards the future, I think we need to better equip the court against misinformation and disinformation. I would suggest, should there be maybe a disinformation task force? How should we revisit some of the communicative structures of the court as we discussed in the last panel? Lastly, let me mention that I think more proactive engagement also with journalists and media from the global south will be particularly crucial, I think, in order to disentangle some of the divides that we have. My second proposition relates to the idea to conceive the Assembly of States Parties a little bit more as a mediator or as a broker for some of the conflicts that the court is facing. My colleague Salvatore Sapela, when he was asked, he said the court needs a political arm which, without interfering, can handle political issues. So, and I think this is an interesting and important proposal, particularly also in relation to how we navigate the relationship to non-states parties. Should there be, through the diplomatic channels of the ASP, not a certain extended arm of the court when the consultation mechanisms under Article 97 of the statute, they might not always work. So I would argue that there's merit in the consideration of a targeted and sustainable coordination structure beyond the bureau in the assembly, potentially composed of state representatives, experts, and stakeholders, also in transitional justice and rule of law assistance, to consult and coordinate a little bit more collectively on these systemic dimensions of complementarity, on the relationship to non-state parties, or even to address peace and justice conflicts. David Schaffer has proposed a select committee of ICC states parties, particularly in relation to non-state parties. So I think these proposals go into the direction of helping the court also, I think, through the functions of the ASP. My last point relates then to procedure, coherence, and fairness. We were asked to reflect what are also some of the recommendations that we would take on board, maybe from the independent expert review. So I would argue that developing foresight and predictability within the ICC system, Leila, you referred to the jurisprudence on motive liability, developing more foresight and predictability in the ICC system, I think will be crucial towards its credibility. So pre-thinking some of the implication of cases, I think there's a very good recommendation that while the ICC has no rule of precedent, but in case if you deviate from an appeals chamber decision, that you at least give notice to the parties so that they can actually adjust to some of the potential ramifications of these decisions, so that you gradually build, I think, a more coherent process. Secondly, I think this idea of investing in the quality of the deliberative process and this culture of collegiality at the court, I think, is also very important. For instance, sharing dissents before the drafting of the majority decision, I think is a very compelling point. I think one of the strengths which Claus has also seen of the ICJ is the quality of the deliberative process, and investing in this would be, I think, a very important move for the ICC. Going beyond these jurisprudential dimensions, we've discussed the peripheries of cases, what happens to the convicted and the acquitted. So we have had long-standing suggestions also, should we have an international penal detention mechanism, for instance, to alleviate the court from always having to seek a state which then enforces a sentence and which ensures a little bit more equivalence also of conditions of enforcement. And last not but least, again, going beyond imagining the system, and Chief Taco spoke about it, is imprisonment and is retributive justice really always the answer to atrocity crimes? We've seen processes like the Colombian justice process, which has had new approaches towards alternative sentences, towards rehabilitation. I would argue there's something that the court can learn. I don't say the court should adopt these practices, but I think there's much that the court can also learn from these practices. Thank you.
Thank you so much, Carsten, for this second firework of ideas. I thought it was an exciting suggestion almost every 30 seconds of your talk, and I regret a little bit to hastily make the promise to you not to use my capacity as chair to ask questions first, but I shall abide to it, of course. Paola, it is your turn now. A very warm welcome again, I guess, from Geneva. Please.
No, indeed, I'm in Italy. I could not travel.
You're in Italy.
Can you hear me?
We envy you. You have the floor, please.
I'm very sorry not to be with you in person, but I'm happy to see that my back has this very important room where I've been a few years ago, and sorry not to be with you, and also not to have an opportunity to see the public and the audience. I would like to say to you that while my predecessors and Carsten and Leila have been really fireworks in making proposals, and I will be very full of criticism, if you allow me, because I think that, as you said, Claus, at the beginning, sometimes I cannot avoid criticizing the court, but not because I don't like the court, because I like it very much. And I always say to my students when I criticize the court, it's like when you love someone very much, then you wanted to make it better. And therefore the criticism that I raise is because of the importance of the court in the international relations and the affection I have for such an institution. Having said so, if you allow me, I would like to speak briefly in addressing my criticism, let's say, on a question that seems to have become a dead pattern, namely the question of the relationship between the Security Council and the International Criminal Court. I guess that everybody would know or would remember that when the International Criminal Court was created and the Rome Statute provided for the possibility for the Security Council to trigger the jurisdiction of the court. The proponents of this view saw in that possibility a golden opportunity, namely to say, well, the Security Council would not need anymore to create ad hoc tribunals facing atrocities, would not need to create another ad hoc tribunal as it did for the ICTY and ICTR, because the ICC would be at the disposal of the Security Council whenever it is needed. And as we know, I mean, the Security Council has used this opportunity only twice for the situation in Darfur, Sudan, and then with Libya, and then it has stopped. And then, as we know, in both resolutions, the Security Council has indeed put a few controversial aspects. One of them has been the fact that in referring the situation of Darfur and Libya to the court has said that nationals serving as officials of contributing states, of states not parties to the ICC, former or current officials of these third state parties to the Rome Statute, but these people should have been subject to the exclusive jurisdiction of the contributing state. And this has been very controversial, exception to the jurisdiction of the court, and I will explain more about that in a moment. And then a second controversial part of these decisions of the Security Council was that the Security Council was underlining that by referring the situations to the court, it was not ready to take any financial cost following the possible investigations by the International Criminal Court over these two situations that were referred to the court. And in both cases, as we know, both in the case of Darfur, Sudan, and Libya, the referral concerned situations occurring in states not parties to the Rome Statute, and therefore this was the only opportunity for the court to investigate, because the preconditions for the exercise of jurisdiction based on nationality or territoriality were lacking. Now, we know very well that this has been the history has been that then the Security Council has not used anymore its power to refer situations to the court. I will discuss it in a moment, but I would like to underline that the International Criminal Court, when it has received these two referrals, seems to have accepted also the restrictions that the Security Council has put onto the court. And this, in a way, to me, it was very problematic, because it was demonstrating that the Security Council could have used the court as a court à la carte, namely modifying the Rome Statute, in particular when it comes to the reach of the jurisdiction of the court, and also by not really taking the financial cost of triggering the jurisdiction of the court over situations occurring on non-state parties. So the impression that I had from the fact that the International Criminal Court has accepted the referrals without pronouncing upon these two limitations put in the Security Council resolution, in a way was as if the court said, okay, the Security Council in this case is my master, can put limitations on my jurisdiction, then I'm happy with it. Now, I don't want to enter the politics of justice, but from a legal perspective, this could have been an interpretation that the Security Council could, by triggering the jurisdiction of the court, dispose of the court jurisdiction. But then, how it comes that since the court seems to have been complacent with the Security Council, no decision to put limitations to the jurisdiction of the court, then the Security Council has not used anymore the court for the future. And I think that, of course, the geopolitical conditions have changed, and we can discuss about that. But also, I think that there has been something that has occurred. Meanwhile, from the court side, that, as we know, is the al-Bashir case, when the Security Council referring the situation of Darfur to the court. I don't think that the Security Council members were expecting that the ICC would have indicted the sitting head of state of a state not party to the Rome Statute. But the court, as we know, has asserted its personal jurisdiction over al-Bashir, and has also, after a very long judicial history, then in the end has motivated also its capacity to ask for the arrest of the sitting head of state of a third state party by member states, even though in principle, he was entitled to international immunities as a head of state. The court, as we know, has finally suggested a way out to say that there is customary rule derogating from this rule, or the Security Council resolutions in principle would have allowed such an interpretation. And I think this has been, in a way, perhaps one of the factors that has contributed in the long run, perhaps, the Security Council not to trigger anymore the jurisdiction of the court in situations occurring in states parties or non-state parties, also because the outcome could have been in a way to send an arrest warrant against the person with whom then you have to make peace in a way. So that's, I don't know, that's something that I would like to discuss with my colleagues and perhaps during the Q&A. But I think this has been some sort of not a great strategical decision by the ICC to continue with the al-Bashir case when he was head of state, leaving aside the legal interpretations that we can give on the law on immunities. Then having said so, I don't regret personally very much the fact that there is some sort of separation now between the Security Council and the ICC. I'm not saying that I'm nostalgic about the fact that the Security Council is not using anymore its powers under the Rome Statute to trigger the jurisdiction of the court, because in the end I think that it's much better this way, because it is good that the ICC is in a way separated from the Security Council as much as possible, and once I would go for such a divorce, because I think for the legitimacy of the court, it would be much better to act independently of the Security Council powers. But therefore, I think that if I should see something that for the future I would expect from the court, now that the divorce between the Security Council and the court seems to be realized de facto, is that the court goes back to the origin of why it was established. I think it's very important, and I think it is here that the court has not yet fulfilled the promise. Because after all, when the court was established, we were still thinking of the fight against impunity. And when we think of impunity, which kind of impunity we have in mind is something that in that courtroom should be very present. I mean, often one should also look for the officials of a state that commit atrocities, those in power committing atrocities, not necessarily non-state armed actors of course, corporations, business entities, everything that Carsten has so importantly highlighted. But let's not forget that the impunity is also and foremost about against those in power, for which it is very difficult to have justice at the national level. And I think, having said so, I would also think that it is important for the court to strengthen the Rome Statute vis-à-vis the state parties, and therefore to use the possibility to exercise its powers vis-à-vis member states, including those in power on those member states, rather than necessarily going outside the Rome Statute to go after those in power. I think that the message would be much stronger if the court would reinforce its original design, the reason for which it was originally established. In this respect, I think that we really very much need such a court. Now, we know that the court has now recently changed a bit. The prosecutor has changed his strategy, and finally we have preliminary examinations and investigations over countries not necessarily linked to Africa, and then in relation to member states. So let's see what will happen out of those recent changes, and I very much hope that the court will take such a road, because this will certainly something that we need to strengthen in contemporary relations. That's it. Thank you.
As expected, Paola, the number of the fireworks are 3. And thank you for being also critical, partly critical. I can see already some movement here within the audience. But I would kindly ask the audience, for those who have begun to queue, for their indulgence, because I would like to make a few observations of my own, complimenting them initially that they will, of course, be completely in my scholarly capacity. I think it must have been almost there, close to where the president is now sitting, that Robert Jackson took the floor in his inaugural address here in this historic courtroom, and it has been referred to it numerous times, the moment of birth of international criminal justice in its strict sense. And there is one famous part of this inaugural speech by which I would like to premise my observation, and most of you will know it, but I won't resist the temptation to read it out here. And it goes as follows. The ultimate step in avoiding periodic wars, which are inevitable in a system of lawlessness, is to make statesmen responsible to law. And let me make it clear that while this is first applied against German aggressors, the law includes, and if it is to serve a useful purpose, it must condemn aggression by other nations, including those which sit here now in judgment. This sentence has resonated with me ever since I have been engaged in the negotiations on the ICC statute and on the crime of aggression in particular, but it has been resonating with me, and I think it should resonate with all of us much more acutely since 24 February this year. I wish to remind you briefly that when we speak of the birthplace of international criminal law, yes, it was the birthplace, very importantly, for the prosecution of war crimes and crimes against humanity. But the major ambition, at least of the United States, but also a point to be remembered today, Russia, the Soviet Union, was to set a creative precedent against what was formerly called crimes against peace. Today, the crime of aggression. And there was a historic need to set that precedent felt most vigorously. Of course, the immediate moment that triggered it, Germany's catastrophic wars of aggression and those by Japan, but the challenge to this fundamental change in the international legal order to move to a prohibition of war with the Briand-Kellogg Pact had begun earlier with Japanese invasion in the Manchuria and then Italy's brutal war in Abyssinia. There was a sense that is articulated in Robert Jackson's sentence here that an important cornerstone of this new international legal order, the prohibition of the war, still young, fragile, is challenged at its core. And that, now returning to Beth Simmons' magnificent intervention yesterday, that also the instrument of international criminal justice should be used to make an addition to meet that challenge. And what is also powerful part of this powerful sentence is that it can serve this purpose only if this is not a one day, an isolated precedent, but if this is generalized, universalized. If this is applied not only to the German aggressors, but to all concerned, including those who were sitting here represented on that bench. And again, Beth Simmons, in her intervention yesterday, explained that much more detailed than probably Robert Jackson conceptualized it at the time. Why, in order to use that purpose, we need that generalization. If we want to use international criminal justice also as an instrument that can add to strengthen, well, under the UN Charter, no longer just the prohibition of war, but the prohibition of the use of force, to which the ICJ referred as a cornerstone of the UN Charter, and which is referenced, as we have heard it by Christian Wehner-Weser, in the preamble of the ICC statute. So nobody tell me the ICC has and should have nothing to do with strengthening the prohibition of the use of force under its proper name, not through any backdoor, but spot on. We all know this call by Jackson for a generalization of that precedent has been unsuccessful for a very long time, and it has remained unsuccessful even in Rome, if we are honest. It was a matter of last seconds, and I remember this vividly at the Rome conference, whether the crime of aggression by name would be even mentioned in the ICC statute. It could have been, that was a real chance, it could have been left out completely. Why was this, though? Two basic reasons. The first of all, of course, power politics, and I will not go into the details except for one thing. Not power politics by African, Asian, South American states. They were overwhelmingly in favor of including the crime of aggression. These were power politics by Western states. I'm not saying that Russia was enthusiastic about the idea, but let's be honest, power politics by Western states, in important parts continuing to that day, that prevent us to get serious with the use of international criminal justice in order to protect the prohibition of the use of force. And then secondly, a development on which we can discuss, which I have come to be very doubtful about. And scholars have been very active here to take our share, to establish a conceptual distinction between a category of atrocity crimes, including war crimes, crimes against humanity, and genocide, and then to create the idea as if the crime of aggression is something fundamentally different, almost anachronistic, about an outdated value of state sovereignty, having nothing to do with human rights, individual values. I wonder how Ukrainians would see this logic. I wonder how soldiers who are killed in war, in compliance with the law of armed conflict, civilians who are killed as the result of a military attack not causing disproportionate civilian harm, and thus completely lawful under the law of armed conflict, how they view this idea that aggression has nothing to do with individual values. Now, this is a very problematic distinction, and I have to say, and we have to be honest here as well, a distinction that has been very influential on influential human rights organizations within the coalition of the ICC, Amnesty International, Human Rights Watch. Bill has reminded us how important, fundamentally important, the coalition was to advance the international justice enterprise, and I could not agree more with him as having been member of a delegation of the like-minded movement. Without you, the coalition, you are probably right. It's a question whether we would have come so far. But you and I, we also know the coalition has been, let's call it diplomatically, much less enthusiastic in supporting those who wanted to include the crime of aggression with a principled jurisdiction. And this is why, and the reason is because organizations such as Amnesty International, Human Rights Watch, until today, take the position that this is something fundamentally different and perhaps not worthy of such an investment of energy to make it full part of the ICC statute. And these two reasons have also made it difficult then to fulfill the promise that was given in Rome in the end as part of the ultimate package to continue to work on a definition, on a jurisdictional scheme, and to ultimately include it somehow. And you have rightly said, Leila, and we have said it on numerous occasions, probably the year 1998, that would not have been possible to be repeated later. And still, isn't it not spectacular in a sense that the jurisdiction over the crime of aggression ultimately was activated in 2017? Quite a few people don't even know that, don't know that yet. In terms of publicity, there could be much more information about this fact. It happened despite continuous powerful opposition and despite reluctance of some human rights organization to support it. Yet, and Leila, you have referred to it, Christian Wienerweser has done so, Richard Goldstone yesterday, the jurisdictional scheme is different. It is different. It is so restrictive that at this moment in time, the ICC, the hands of the prosecutor are tied with respect to that crime that should be at the center. Because not only in the view of the Ukrainians, when I speak with them, the original sin of what we are experiencing now in all horrors, this is the war of aggression launched against Ukraine. I'm not diminishing here by 1 second the horror of war crimes, crimes against humanity. And I'm not diminishing by a second how important it is that the ICC invests all its energy to go after those under suspicion to have committed those crimes. But let's face it, the law, and we have not been facing it before, because the other situations before the ICC have not involved such a situation, Christian Wehner-Weser mentioned it, the law as it is currently being applied is internally selective. We are not applying the full body of customary international law. And the ICC is not to blame for that. It is not the responsibility of the International Criminal Court. This would again be a matter for public outreach to make that clear. It's not the responsibility of the prosecutor. The prosecutor has to respect unprincipled political choices for which largely Western powers are responsible. And this is why, to repeat Christian Wehner-Weser's term, we are faced with a glaring challenge today. We are faced with a glaring challenge if we believe that international criminal law, in addition to the conduct rules of the law of international and non-international armed conflict, most basic human rights principles, has also to contribute to, again, this cornerstone of the UN Charter, the prohibition of the use of force. And what we are now facing to risk in the situation of Ukraine, if nothing is done, this is the risk of a negative precedent. It is the risk that at this historic moment in time, where the challenge to the prohibition of the use of force under current international law is so serious as I would argue never before since the entry of the United Nations Charter, nothing will be done about the particular crime that is devoted to meeting that challenge. And it provides me with only partial comfort that prosecutions with respect to other crimes are ongoing, because we have made this point again and again, also today. Precision, fair labeling, correct labeling is important. So it just matters whether it's only war crimes, crimes against humanity, or that crime which is on the minds of everybody. So, to conclude, what should be done? The first question is not one I will elaborate upon any further, but I will just say, together with Christian and Richard Goldstone, in my view, something must be done now. Carsten has spoken of the polycentric system and the ICC being a part of it. If people say that by the establishment of a tribunal to deal with this glaring gap, challenging gap, the ICC could somehow be damaged, I'm honestly speaking at a loss how this could be if the overall purpose is to work against immunity comprehensively with respect to all crimes. If complementarity is an overarching principle, how can the ICC be seen to be damaged if a complementary structure would be there to do something that the ICC legally cannot do now? But this is something I will not pursue because we are asked to think about the future of the ICC. It should be no doubt in our minds, I think, that the ultimate solution for this challenge that has become so glaring now should be in the ICC statute itself. I don't think there is disagreement here that a special jurisdiction, be it for Sierra Leone, be it for Cambodia, for whatever situation in the world, is never in terms of institutional design, in terms of elementary aspirations to fairness and justice, the ideal mechanism. This is this court. This is the best institution we have, and this will remain the case for the foreseeable future. So the solution should be found in the midterm within the ICC statute. And this juncture, this crucial juncture now, should give states, and I appeal in particular to Western states. I don't think it would be difficult to convince African states or South American states who have during the negotiations pleaded for a broader jurisdictional regimes. This should be a moment for Western states to reconsider the position they have taken. And don't tell me it's difficult to change the ICC statute. There will be opposition. It's a long-term process. If those kind of considerations would have hindered us to take action, we would not have been where we are today. If we think that with respect to a fundamentally important point, the system is still deficient, and that's what I firmly believe, then we should do something about it and encourage states to do something about it. And I would enthusiastically invite those human rights organizations not yet fully convinced to join and to help. The avenues are perfectly obvious. Article 15 bis of the ICC statute, but now, and that's my final sentence, I meet Carsten Stahn's, one of his brilliant ideas, uniting for justice, you call this, a more important role for the General Assembly in terms of referring situations to the ICC could also be a remedy with respect to the crime of aggression. I hope the Nuremberg Academy, we can also be a little bit encouraging about what the Nuremberg Academy could do. I hope the Nuremberg Academy, that has also not been particularly active on this specific issue, if I recall, could turn its attention at this important moment in time to this topic, perhaps even next year. I thank you very much for listening. And give the floor to Jennifer.
Okay. Well, thank you very much. That was packed full of really, really provocative and interesting ideas that we will all be thinking on in the coming days and weeks. But let's add to that while we're at it. I will start with Dr. Chaladi. Thank you.
Is it on? Yeah, okay, good.
It should be okay.
Thank you very much for a very exciting panel. I'm particularly pleased, Klaus, that you made us wait because, as always, your words were very inspirational and thought-provoking, and I agree with every word that you said, actually, in your intervention. I recall also, Bill, you might remember, I think it was conference room 6. You and I and Richard Dicker had a rather uncomfortable conversation about precisely the point that you're making. So I'm really grateful that you made those points. But I had stood up to ask for the floor really to make a couple of comments or questions actually on the UN Security Council questions and issues. And I'll start with Paola. And in particular, the limitations that you identified. So I think you identified the two limitations, the outset jurisdiction and the finance jurisdiction. It was in 2012, I recall, at a workshop in Laguna Beach, where Christian Venavesa said that actually the General Assembly is fully entitled to simply ignore that provision because, after all, the role for finance is left under the Charter to the General Assembly. But in your intervention, you questioned whether, and here I'm going to defend the ICC, I guess, you questioned whether the ICC ought not to have, upon receiving the referrals, made some sort of a declaration. The question that immediately struck in my mind was whether or not, in fact, the ICC ought to have simply ignored, I think it was paragraph 6 in the 1593 resolution. Of course, there's two parts to the ouster jurisdiction clause, right? So the first part is the ouster of the ICC's jurisdiction, and I think the ICC is not a party to the Charter of the United Nations, so certainly it's up to the prosecutor and the court to decide that they are not going to follow that without making any kind of declaration. I think the more problematic one for me, in fact, is the ouster of national jurisdictions as well, which is also contained in those paragraphs. And so I wondered what you think about that, whether or not it would have been appropriate, or it would be appropriate for the ICC just simply to ignore the ouster of jurisdiction clause. And then to Carsten, I mean, needless to say, I fully agree with your suggestion, which was endorsed by Claus for the Uniting for Justice. And of course, as you mentioned, it would require an amendment to the statute. One thing that this raises, now this might be slightly controversial, is if you're going to amend and I think Leila knows exactly what I'm going to say, I can see by the nodding of the head. If you're going to amend, I guess, Article 13 of the statute to permit the General Assembly to also make referrals, would it not be appropriate at the same time to also amend Article 16? Because really what you're looking at is you're looking at the relationship between the court and these other organs, and I think it's only fair if there are so many problems with the Security Council that you also don't think about affecting and amending the deferral powers. And I'll stop there. Thank you very much again for a really great panel.
Yes, yes. Chief Tato, please.
Very quickly, I have two problems. One is about people who come within the jurisdiction of the court. The court warrants. The court issue a warrant, and these people are killed under circumstances that are not known. No investigation is conducted or to find the killers. I've also had situations where the court have issued summonses to appear. It has encouraged people to come, and sometimes it is coming person to warrants that people feel safe, they're alive. Now, I have in mind that United Nations referral you talk about, Muammar Gaddafi. Once the referral is made, the warrant is there, he's killed. The Security Council does nothing, nobody hears anything, and the situation of conflict continues. It is reasonable that there should be an investigation. Secondly, the Security Council must do more. They should not give the impression that the court is being used only to advance its responsibility to protect mandate. It should be that they recognize that the court justice, international justice court, is the best way of resolving that problem. The second issue is the status of the acquitted and the convicted persons before the court. The Security Council itself has demonstrated that it's unable to protect, to find a solution to 8 of the persons in the ad hoc tribunal. Many of them are acquitted, others have finished their sentences. They are stateless, nobody knows. Now, with regard to United Nations referrals to the ICC, potentially we'll have, for now, as I said, the ICC has not yet been confronted with this, but 15 to 10 years, 20 years today. This example of the Niger 8 sends a wrong impression to people that coming before international justice just matters worse. It gives them a status which is dishonorable to international justice and the legitimacy of international law as a means of resolving conflict situations and punishing crimes, or doing supporting the objective of the United Nations as stated in the preamble of the Rome Statute. Thanks.
I complement what they say. I think it's the same question, or same comment on the same topic. But whether, I think, okay. Because I think what they are questioning and the panel was discussing is the interaction between the political decisions and the judicial decisions. That is, for me, the topic of the panel. And for me, it was very interesting to listen. Most of you were from Europe. I spent a lot of time in the US now. The discussion there, the discussion at Harvard emphasized political decisions. The Welfare Center on Security discussed how to bomb better. That's what they discussed. So law is irrelevant. So here is a more legalistic discussion with grades. And that for me was very interesting. Now, I agree with Claus, and that was my point also, my presentation. The issue is aggression crime. No, the court, not just Jackson present the issue, but the court agreed with him and called crime against peace include all the other crimes. So I agree with you that emphasis should be on the political side. I think Leila provided a very interesting analysis showing the evolution, how things were evolving, how the prediction at Rome what would be very controversial relation with states, but we managed to have Uganda and Congo referrals, and we start easy. Not just helping the investigation, also reducing the political tension, the frictions. For me, something more, my comment was more in the direction of Carsten and Gaeta. Because I think Carsten presented a very interesting perception of what should be the next case. And then, instead to emphasize what the political side could do, you presented a very interesting idea. Okay, the court should emphasize a specific type of crimes. And we are not debating enough the world of corporations. But that point, which is interesting, is like ignoring that the world is going to a very difficult political system where the war is part of the game. Not just the war in Ukraine, the war on terror continue. The war on terror continue, the US has authority to bomb and kill people in many countries. And that is aggression crime, in fact. So that's the point. Should the court focus on a specific case, ignoring the political reality, or the emphasis should be, as Claus presented, the topic is political reality, war, aggression crime should be stopped. My last comment is, my feeling is, I think you agree, that's why the future is not so much about the court, that who should be doing, the future is how the political community will include justice in decision making. And that's my final point. On talking about evolution, the Security Council resolution on Darfur was the result of political decisions of state parties. So France and 8 state parties lead. That's why when you present as an imposition of the Council on the ICC, on the contrary, Darfur referral was an imposition of the state parties on the US. Of course, there were agreements and negotiations, but it was a political decision by state parties to push. And that we will miss in the next 3 years. We will miss, because in fact, the evolution was, there were 2 abstentions in the Darfur referral. In the Libya referral was consensus. China, US, both in Russia in favor. Okay, that was the situation in 2011. And that for me is what look, we came from, I think 2011 was the peak and the end of the political support. Syria destroyed this. So my point is, I think we really need a dialogue between political science and international relations and lawyers. That's why what Beth is proposing is very interesting. But I think we have to be careful on not replacing aspirations for the legal system. When we received the referral, the state parties accepted, we have a budget, so I had no American or non-state party suspect, so I never had a conflict with the referral of Darfur or Libya, so there was no problem to accept the referral. It was my job. When we indict, and you say, Security Council is in the statute. A referral from Security Council is in the statute. The statute accepts the court working as an ad hoc tribunal for the Security Council. That's legal. Yes, yes. Security Council refer cases. I'm sorry. Yes. She's nodding no, but I think yes. I think obviously yes. And Security Council is also, when we receive the referral, we say, okay, we have the referral. State parties are providing the budget. We move. No non-party suspects. And then in our legal system, Bashir had no immunity. So we decide, and according to the law, that's why you can have your opinions, but I like the idea, I respect your opinions, but I like to be respecting the idea, we never move beyond the legal frame, never. That was, for me, was my only main idea. We stay inside the legal system. And in the Bashir case, we not just prosecute a head of state according with the law, also, according to Article 16, established the Security Council can suspend investigations. So in order to allow Security Council to do their job, in December 2007 and in June 2008, we informed the Council that the next case would be the person who gave instruction to the minister. So we did not say Bashir, but it was obviously Bashir. So, and I did that to allow the council to suspend the case if they want to suspend it. And it's just 1 minute more, because it was interesting. In December 2007, June 8, I informed the council, on the record, I will do the case against the person who gave instructions to the minister. In July, we indicted. In September, I came to New York, and an ambassador told me, prosecutor, how you can indict a head of state without informing us? I said, I'm sorry. On the record, I say, yeah, you say that. We did not believe you will do it. That's what we say. And I was laughing, but in fact, that's showing the different protocols between diplomats, politicians, and lawyers. For me, when I informed them I would do this, I would do it. For the ambassador, I was consulting them. So I'm presenting this story to show two things. First, it was totally legal. What we said was totally legal. Maybe you like it or not, it's fine, but it's legal. And second, to emphasize Klaus' position that we need to focus on the political angle, we need to understand their dynamics, not the legal thing. We need to understand how they think, how power works. And that's a problem with the idea just prosecute corporations, because then we are going to this different problem. So my main point is the future is about political and judicial decision. Political is the biggest challenge, but to change political, we need to understand the political codes, not pretend that we'll impose, and also at the same time the court should remain in its legal limits. That's my point, and thank you for that.
Judge Abu Suji, would you like to go ahead and start? Of course. Yeah, we've had a few comments. Okay, we'll respond then.
I just want to argue that those, when we are kind of attacked, we should have a right to respond. And people who've spoken every single time, that I just don't want to not have the opportunity to respond to Klaus, okay?
Thank you. Would you like to respond to the first comments then?
I was just going to make a couple of very short points while I have the mic. One is that on the crime of aggression, there is one, I want to go back to Christian Venevaser, who said sometimes we need to be creative we need to think about being creative. We can't be creative with the definitions of the crimes under Article 22, but the rest of the statute is open to interpretation because it's the constitution of an international organization, right? It's quite a different, so we need different methodologies of interpretation for the different provisions. On the crime of aggression, I did a project on accountability for the unlawful use of force, and one very clever contribution for how we could do the crime of aggression even short of an amendment in the cases of non-state parties, like the situation in Ukraine, is to use the crime of persecution, which only has to be linked to another crime within the jurisdiction of the court, and aggression is another crime of jurisdiction in the court. And so what I want to say, I didn't say in my opening remarks, this is a crimes against humanity court, and I don't just say that because I'm the special advisor on crimes against humanity. More than 30% of the cases in this court are crimes against humanity only cases. There are no war crimes charges. Philippines, Venezuela, Kenya, you can go on and on. And so one of the ways I think we can think of the crime of aggression is to say it's still in the statute, even if we can't indict under it. And I don't disagree with you, Klaus, that we need a way to do it more directly, but I think there's some very creative ways that we can do it indirectly, even using the Rome Statute framework that we have there. And then I just have one other point to Diri. I am very wary of the General Assembly as a referral mechanism because of the Article 16 issue, and because I actually do think that if the UN Charter is the constitution of the international community, the Security Council does, at the end of the day, have a different role than the General Assembly. Maybe that makes me the pointy-headed lawyer who's boring and pushing back a little bit, but I do think that expansion of the General Assembly's power in cases involving non-states parties to the ICC it just gives me some pause for a variety of reasons. Thank you.
Thank you. First of all, in relation to the crime of aggression, let me add my voice to Claus. I think it's entirely important to strengthen the ICC system at this very point in time. So I think solely discussing the option of an aggression tribunal in isolation of also talking about the ICC is a sense of wrong signal about selectivity, about not learning from the past. I think we have to be more forward looking also in relation to the ICC system. At the same time, I would say even if we were to give the ICC the jurisdiction of aggression, the ICC would still only do a limited number of cases. So I would argue there might still be space for another entity to deal with the magnitude of crimes. I would argue that it's also wrong to simply isolate a tribunal on the crime of aggression, because I fully agree with your point, Klaus, that the crime of aggression is inherently related also to the criminality of other crimes. Particularly, it would be artificial, I think, to only focus a tribunal simply on aggression without, for instance, also not looking into war crimes, not looking into the impact of some of the aggression crime and their context. All of the other tribunals have had the nexus to the other crimes, so it would be really artificial now to create something only for aggression. In relation to the point by Direct, I fully see your point. Why, if we give the GA the power to refer, why not defer? I think theoretically your argument is right, but I think the more appropriate reflection is, for what purposes do we actually want to use Article 16? And I think we have not a very credible history as to the motives which have been used in order to say that there's a threat to international peace and security, arguing that the ICC in itself presents a threat. So then it's not in uniting for justice anymore, but it's really turning and spinning the argument around. So I would argue you could also very well distinguish Article 13 from Article 16 powers, and the 16 powers, I think, have that troubled history, so we might want to reflect also in the future how, with further Security Council requests, we might actually refine this. In relation to the point by Luis Moreno Ocampo, I fully agree. There's always a need for the ICC to treat ongoing political contacts that will never go fully away. But what I would argue is that in addition to that, the ICC should not only hush after current situations of political violence, but there will be a tipping point in the future where the added value of the ICC, because you also have other entities going after the current atrocity crimes, there comes a tipping point also for the legitimacy of the court to go for those crimes which are neglected, which are much slower, which are much less visible. And I think here the court has an important role, and I think nobody would dispute that environmental crimes are a cardinal example where the ICC could really make an important difference. Thank you.
Yes, I would like to respond, first of all, on the Security Council referrals concerning the fact that the court could have ignored, let's say, the limitation on jurisdiction which was put on the Security Council referral. I guess that, if I look at the practice of the court or the prosecutor of the court when it comes to the so-called self-referrals, for instance, in the case of Uganda, the first self-referral, there was the attempt by Uganda to say, well, the referral that I make is only vis-a-vis, the crimes committed against my forces, committed by the rebels against my forces. So it was a sort of limitation embedded in the letter of the referral. And the prosecutor correctly clarified that the referral for me is accepted, but I will investigate every crime without any limitation whatsoever. And I think this was a very good assertion by the prosecutor that I would have liked to see also when it came to the Security Council referral and so-called jurisdictional limitation that is broader than the jurisdictional limitation on the court, but as you say, is also has an effect on member states because they, according to the Security Council, they could not have a jurisdiction over members of contributing states. So that's the point. And then when it comes to the financial limitation, that is true. The General Assembly actually could have financed the investigation of the court in Darfur and in Libya. It has not done so. But nonetheless, I think that the message of the Security Council, by referring a situation and saying, I don't want to support any cost, is a clear message of some sort of not full support of the referral. So I think it's quite problematic from the political point of view. Now, coming to Moreno Campo, of course, I mean, when I say no, it's not saying that the Security Council has no power of referring a situation to the court, but there are two ways of reading this power of referral. There is the way of saying, okay, whenever the Security Council makes a referral, it gives jurisdiction to the court as if it is creating an ad hoc tribunal, but indeed is not, because it does not pay for it, it's not a subsidiary body of the UN, and then it does not really request non-member states to cooperate with the court. So, I mean, the Security Council, to me, when it refers to the court, it refers to the court situations, but then the statute cannot be modified. And therefore, the jurisdictional limitations should not have been there, first of all. But then you're right to say, okay, but we had jurisdiction over al-Bashir because the Security Council referred the situation to the court, and we have Article 27. And I've written on that. I agree with you that there was jurisdiction over al-Bashir. I debate about the opportunity to do an indictment against al-Bashir at the very beginning of the court, to start with the sitting head of a state of a non-state party. I would have liked to see an indictment against the sitting head of state of a state party, at least as a starting point, which this is possible under the statute. But then I disagree with the court when it has said then there is no immunity when it comes to the arrest of the sitting head of a state of a non-state party. But I've written on that, I've been not followed, I'm happy with that. But I mean, I think then one has to distinguish the two hypotheses. So what I think is preposterous, so sorry to insist upon that, that after 20 years, we don't have any Westerner indicted by the court. I mean, we shall not, I mean, this is the court for everyone. Why don't we have a court which is bold enough to do its job, which is also to take into account that also leaders of Western countries may commit and may be responsible for crimes? Can we give this important sign to the international community that this is not the court of the West? And I think it's important, and I stop it here, but that's what I think is my main point.
Bill, we still have 10 minutes, Bill, if we can give you the floor to make your remarks. Thank you.
Thank you. Governments have constitutions, nonprofit organizations, issue organizations have mandates. To ask an organization that has a clear mandate to go outside their mandate because you think that their mandate is too restrictive is, I think, very unfair and unreasonable, and it's kind of a thing academics do around. The agreement in the Rome process was by 1996 that we would limit it to the 3 crimes for which 165 nations had already ratified definitions. There was arguments that for the last 27 years, environmental organizations have been yelling, why didn't we get environmental crimes in there? Others wanted corporate crimes. Others wanted drug trafficking and terrorism. But it was clear that it was going to be the 3 crimes for which there was already 165 governments that had ratified. And that's how the like-minded group, the 70 to 90 countries that really delivered this, the small and middle power democracies and supporters, got it through. You've admitted that you think that we just barely made it through on July 15th, 1998. You admit that we barely made it. In fact, the ICRC didn't even come on until the last days or so because of what they wanted to have. So in 2002, you had a terrible Chapter 7 resolution of the of the United States in the Security Council in the UK. So I think it's important to remember how we actually got here. It's only academics that don't realize and say clearly that that one of the key reasons that we got the Rome Statute was the coalition for the ICC. The government say that, the Assembly of State Parties say that, India and others who opposed, who voted no say it. The Kofi Annan in the UN had been clearly saying it. So it was a very close, difficult thing to be able to achieve. At the time of the aggression negotiations a few years ago, 2 or 3 of the permanent members had just committed acts of aggression. If you think that that Amnesty International and Human Rights Watch supporting the crime of aggression getting the same jurisdictional support as war crimes, crimes against humanity, and genocide, I think you're extremely mistaken on that. And now, I do think, for example, with environment, with ecocide, I think we have a chance to move forward. And in the 5, 10, 15 years, I think that's what would be important to do. 2 30-second things. One is on archives. We really need to get archives saved on all these processes. Many of the institutions I'm talking to, for example, are only keeping the very last piece of the legislation that finally succeeded. All of the legislation that was proposed that built up to that isn't being kept, etc. So I think if we're going to have a proper history, we need organizations like the Academy and others to be sure that they're trying to keep these archives. I'll just finish. As one of the first things Christian said the other day was how crucial it is to have basic education. And to paraphrase a famous historian, the history of civilization is a race between education and catastrophe. And Einstein, one of the greatest Germans in all history, said something very similar about the great achievements of civilization are like monuments in deserts of shifting sand. And if they're not eternally paid attention to and shown vigilance, they could disappear with 1 or 2 storms for the ages. Thank you very much.
Did you still have a question, Judge Ebo-Suji, or a comment? Did you give up? And we have one from Professor Erwentlicker as well. And then perhaps we should...
Thank you very much. I mean, you did not see Claus invite me to come and speak, but he did. That was an exciting panel, by the way, and everything you said, Professor Kreß, I completely agree with every single thing. And yes, the Rome Statute needs to situate the crime of aggression fully into it in the same way as the other 3 crimes. And Professor Sadat is quite correct that there could be other ways to try and compensate for that through some creative thinking. That's important too. But I do think it's important to stress the importance of the crime of aggression to our world. And we may begin by deleting Article 15, base 3. 15 base 5, the one that says the no jurisdiction over nationals of non-state parties. We need to do that. Now, Professor Stahn, great interventions as usual as well. The only thing I would not do is call the ICC into this thing of lawfare. I would stay away from that. By way of situating with value of the ICC to the world, but he tends to de-objectify, basically remove the objectivity of the ICC and make ICC a partisan tool of people who are fighting. I think I like to use a traditional conception of judicial or pacific settlement of international disputes. I think that's what the ICC is about. Now, Professor Leila, back to you. Your intervention, Professor Sadat, about Article 25, well received, and the try to do that. We've tried to do that in Tagenda. You can read the separate opinion there. And the thing, of course, the difficulty judges have is how, well, in a bid to simplify something, so okay, there's a simpler way of, going about a construction that people may have complicated needlessly. You use more words to try and make things simpler. The problem with that is you create more words. That's how you end up having 400 pages, or 100 of which are explaining how we arrive at the conclusion that customary international law never recognized immunity before international courts, just to demonstrate how other courts who have done it using fewer languages to say so, got criticized. Now we try to say, okay, now here is a comprehensive analysis of that, and then people don't read it. So they prefer to read one block, pages, the page block stuff. But again, moving forward, so these are some of the complications we face. And Professor Gaeta, good interventions. The difficulty I have with your analysis was two perspectives. One is to say that the indictment of a head of state of a non-state party was a strategic mistake. And then you say, never mind the law. You can replace the word strategic with political. That's basically the point, that there's a political mistake. Then why do we have a legal instrument called the ICC? What is the purpose? Why did the Rome Statute, why did the states say, hang on, there has been impunity all along, we want to stop it? Wasn't it because of these political calculations that had gone on for so long? So how does a lawyer reconcile this thing to say, well, forget the law, follow the politics? That's one difficulty I would have. I also have some, questions about the observation that perhaps the reason why there were no longer referrals from the Security Council to the ICC was because head of state of non-state party was indicted. Well, could it be that, or could it be because the African Union were complaining and the Security Council saying all the cases you're referring from the Security Council are only from the African states? We're not going to cooperate anymore, and all the cases at that point that the Security Council had referred were indeed from the African region. Could it be the reason why the Security Council said, okay, maybe no, not a good idea anymore? Could it be because we have had now Cold War II effectively, as at that stage, where you now no longer had that good feeling that happened, after the during the 1990s. Could it be the reason why that's no longer happening? Could it be because there are some states, powerful states, who protect themselves and their clients at the Security Council? So these are some of the questions. The difficulty, I end with back to Robert Jackson's quotes. One of them that always stays with me was that quote that the common sense of mankind, nowadays we can say humankind, right, does not accept the proposition that law would only stop with the punishment of petty crimes by little people. If we say we're not going to indict, legally speaking, the head of state of a non-state party, are we saying it is okay to leave them out but indict the nationals or non-heads of state of non-state parties? These are all the things we must grapple with. Thank you.
Thank you. And we're really coming to the close of the time, but if you can take a minute or two to offer your
I won't take that long. I'm
observation.
going to
Okay.
be very quick. So I don't need to recall all of the reasons why so many speakers have focused on the challenges ahead in overcoming the causes for selectivity in prosecutions. But I do want to not let pass just how significant it is that we are now in a moment that we now almost seem to take for granted, where the ICC is pursuing not just a non-state party, but a member of the P5. And Leila, to your theme of all of the things we couldn't have imagined and have come to pass, 2 years ago, people would have thought I was crazy if I said the ICC would bring an investigation against Russia. So I just think it's worth acknowledging what a significant paradigm shift that already is. And that's really all I want to say. Less than a minute.
Thank you very much. And I would like to thank Professor Kreß for his able chairmanship. Do you have a last remark you would like to make?
The last word is solely to say there could be no better word, final word, than the one just made by my distinguished colleague Diane. And I think we should save our time to give Claus space and you space. It has been a wonderful conversation, lively as it should be when scholars engage in the audience. And thank you very much for your indulgence, for listening to us.
It was really my pleasure to help guide you through this discussion and to close before we hand over to Klaus Rackwitz. I will return to the last motion of Slido. The ICC is on the right track to reach its full potential, agree or disagree? And it has a majority, agree. Well, we're on the path. Let's not forget to document where we've been, as Bill Pace has noted, and where we're going.